So yeah, today I am going to cover an important topic, and this has become, well, it's always important, but it has become even more important with the last two Supreme Court nominations, Brett Kavanaugh and Neil Gorsuch, both of whom are quite conservative. And this has led directly to a flurry of state abortion laws, anti-abortion laws. You've heard them all in the news. These are about as draconian as you can imagine. So today I'm going to talk about, start off by talking about the Constitution. And we have to go so basic because you can't talk about abortion rights without understanding the Constitution, because it is a constitutional right, and we have to understand how it became a constitutional right. You may know that the word abortion does not appear in the Constitution. So how did it get there? So, and the second reason we need to understand the Constitution is because it is also the key to why, in addition to being contentious inherently, right, abortion, right to life, women's right to choose, and so forth, understanding the Constitution also helps us understand why it is so divisive, even more so because of the way that it became a right. Essentially by justices deciding that, yes, abortion is in the Constitution. I hear a little bit of ringing. Is that bothering anybody?
A little bit.
So I'll got a good guy there. And then we'll talk about Roe v. Wade, of course, and then a subsequent case called Casey. And then just take a preview of some of the cases, the statutes that are passed recently by the states. And I'm going to take only about 30, 35 minutes of presentation. I'm going to cut back down a little bit because I know that's just going to be a lot of questions. And a lot of the issues will be addressed during the question and answer. So I kindly ask you to hold your questions and comments until about 35 minutes. Okay. So it's really important to understand how the Constitution works. I know it's very basic, but Article 1, and it's not coincidental that Article 1 talks about the legislative power, right? And that lies in the hands of Congress. So it comes first because the intention has always been that laws and policy are driven by Congress, not the president, not the courts. Article 2 is the executive power, that is the president. And you may know from history that the president never was very powerful, never intended to be very powerful. The executive, their responsibility is to faithfully execute the laws of the United States. Which laws? Laws that Congress passed, right? So the executive is, in a sense, below the Congress. And then Article 3 is even more weak. And these are the words of Alexander Hamilton in the Federalist Papers. He called the third branch of government, the judicial branch, the weakest branch in the government. Because essentially all it's supposed to do is to resolve disputes. Right? It's not supposed to resolve policy issues. It's supposed to resolve disputes among parties who are in the court and nothing else. So then you have to ask the question, well, how do we get to here? How do we get to a situation in which abortion, which is a huge issue, is an issue that really rests with 9 judges? So how do we get here? We have to understand Article 6 of the Constitution, which says that it is the supreme law of the land. So we understand that, yes, Congress can make all the laws, but whatever is in the Constitution is actually above the laws. So that sets up a potential conflict, right? So what can't the government do? Well, this is what the Bill of Rights is about. The Bill of Rights, contrary to the Articles 1, 2, and 7, and 8, and so forth, which establish the powers, the Bill of Rights are the brakes. The Bill of Rights says, this is what you can't do. Right? So Congress, for example, the first few words of the First Amendment, the most famous one, says, Congress shall make no law. So this means all the things that are following are out of bounds. Congress has no authority to, for example, enact laws about religion or the free exercise of religion, or speech, or of the press. In other words, you can't suppress the press. Now, of course, we know that Congress makes laws all the time about speech, about religion, and so forth. So the real question then is, what does it mean to say that Congress shall make no law respecting religion, respecting speech, and so forth? So who decides what the Constitution actually covers, especially the Bill of Rights, especially the limits, is a real important question, right? Because whoever has that power to say what the Constitution says has the power to block what Congress wants to do. And the Ninth Amendment re-emphasizes this point. It says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the people has this residual right, meaning that even if the framers of the Constitution didn't list a particular right that the people have, it doesn't mean that the people don't have that right, right? So the Constitution doesn't say anything about the right to marry, for example, but the right to marry is still something that you have a right to do under state law, for example. And then I'll mention the 14th as well. This is a very important limitation as well, right? It says that no state, because at first we talked about Congress shall not, right? This says no state. And the 14th Amendment passed after the Civil War guarantees a certain amount of equality and due process, which is something we'll come back to later on. So I also have to mention the amendment process, because the framers really had a lot of foresight, and they knew that they themselves didn't have all the answers. So if the people wanted to add to the Constitution, change the Constitution, there's a process, and you know that process probably from civics class, right? You need 2/3 of both houses or 2/3 of the states to call a constitutional convention, to say this, we want to do this. Then you have to ratify it with 3/4 of the states. That's a huge process. It's intended to be hard, not intended to be easy. So this is the way you want to add to the Constitution. So all that is the background. So what we want to talk about now is, so what exactly does free speech mean? What does due process mean? And who gets to decide? So the Constitution actually doesn't say so. The Constitution doesn't say that, Congress gets to say what the Constitution means, right? The way that if this obligation fell to the courts is from the courts themselves, from their own decision. Marbury versus Madison was decided shortly after the framers, right? The Constitution was established in 1789, so this is a little bit more than a decade after. In this famous case, I'm not going to go into it, but it's a wonderful story. It takes about 15 minutes to really appreciate how good a story it is. And you'll notice that Marbury versus Madison, neither of these is Marbury or Madison, because the real story here is really between the Federalist John Marshall and his second cousin Thomas Jefferson, who's an anti-federalist. So anyway, what this case said was basically that if there is a law passed by Congress that violates the Constitution, it is the court's duty to say that and to decide that. And the reason it's the court's duty rather than Congress's duty is because the Congress has an inherent conflict of interest. If they passed a law that they want this law subject to the political process, they're not going to say that, we can't do this. This law, what we just passed, is contrary to the Constitution, right? Of course they'll say this is consistent with the Constitution because we passed it, and we are officers of the United States government, and we also raise our hands to uphold the Constitution just as much as the Supreme Court Justice did. So the Supreme Court says, we get to say what is the Constitution, we get to say whether there's a violation, and nobody else. And interestingly, that's how it's been since Marbury versus Madison. Nobody's contested that. So now the judicial department has this tremendous ability to say that the popularly elected branches, the federal government, Congress, and the presidency, can be overturned by whatever the Supreme Court says, no, 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 this is unconstitutional. So all that is background. Why did I raise this? Because now we're going to talk about how did abortion get here, right? There's no such amendment that says Congress shall make no law respecting getting an abortion. So how did it get to the Constitution? Because remember, the only way, really the only way to say that a popularly elected body like Congress, like a state legislature, that their laws are no good is to say that it violates the Constitution of the state or of the federal government. That's the only way, right? Because otherwise you have tyranny. You have individuals saying, I don't like this law, I'm not going to obey it. So it really is important how you interpret the Constitution. And we've gone through this before. I'm not going to go through it a lot again. Two popular ways of interpreting are saying, like, well, living constitutionalism. This is the idea that a judge can update the Constitution depending on what the judge's perception is of what's the current mores of society. Originalism is a movement by the conservatives in our country, although now it's kind of mixed up a little bit, to say that no, 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 no. The Constitution means what it meant when it was written. And if you want to change it, then go through the amendment process, right? A judge, especially not just 5 judges, cannot just rewrite the Constitution. So that's the crux of the problem. So, how did abortion become a constitutional right? And to answer that question, we actually have to answer or look at a prior case, and I have discussed this before in the prior presentation. It's called Griswold versus Connecticut. Griswold versus Connecticut dealt with a state law in Connecticut that is very common, actually. This law that really limits one's use of contraception, even among married people. It derives from a law called the Comstock Act back after the Civil War. A crusader, Comstock, wanted to just ban all forms of contraception. He thought it was ungodly. And a lot of states, including Connecticut, still had this kind of laws in the books. So if you were, let's say, a married couple, and you were having conjugal relations in your home, conceivably you're violating the law and you can be arrested. Now, back in the 60s when this came out, this is the women's rights movement, reproductive rights, the pill, condoms, and Planned Parenthood wanted to challenge this Connecticut law. And they wanted to say, no, this law cannot stand. This is a new era. And they went to the court to challenge it. Remember what I said, that the only way to challenge a law is to say that it's unconstitutional. So what the court should have said, and the lower courts did, is to say, well, if you don't like this law, then go to Hartford, Connecticut, go to the legislature, write to your congressman or talk to her, and get them to change the law. That's how it's done, right? You can't ask us, a judge, to say, we don't like this law, therefore we're going to change it. I'm sorry, this thing keeps moving. So, but that's not what the court did. What the court did was saying, okay, let's entertain this request. And the judges, most of the judges, didn't like this law. They thought, if the Constitution means anything, it means that they can't barge into a home and observe whether a couple is having sex with contraception, right? It can't be. How can that be a law in the United States when we have all these liberties? But privacy, which, again, another word that doesn't exist in the Constitution, is something that this court essentially cobbled together based on other rights in the Constitution. So they looked at the First Amendment and said that, well, you have a right to assemble and for any purpose that you want to, as long as it's not illegal. So that's kind of like a privacy kind of a right. You can't quarter soldiers in your house. You want to come in? Humanists? We'll take it.
Just put it on the table, please.
I need the receipt.
So the Second Amendment says, the Third Amendment says, you can't quarter soldiers in wartime. So that is also kind of like a man a castle. Sorry, one more time. A house is a man's castle, right? So the idea that there's privacy. The Fifth, you take the Fifth. I refuse to testify against myself. That's a kind of protecting your private thoughts, and all these, and also the 14th Amendment saying like there's kind of like due process. So the judges essentially cobbled together these ideas from these cases, including especially this case, and said that, well, the Constitution actually, I'll just read it. Specific guarantees in the Bill of Rights have penumbras. You've probably never heard that word. Penumbras means kind of like a cloud, emanations, formed by emanations from those guarantees that help give them life and substance. Various guarantees in the Constitution create zones of privacy. And this is how the court did it. It says, yes, contraception is not listed in the Constitution, but the idea of privacy does exist in the Constitution. And therefore, we believe that this law is unconstitutional because it violates everybody's sense of privacy. Okay? Now we get to Roe v. Wade. Because in Roe v. Wade in 1973, Miss Norma McRae, who was a Texan, lived in a state in which she can't get an abortion, it's illegal. She wanted an abortion, and she had a lawyer, and she wanted to challenge it. So the same kind of situation in Griswold versus Connecticut, right? You have a law that she doesn't like, a law that a lot of people don't like, and they wanted to go to the court to try to get the court to say that this law is unconstitutional. So again, the proper route, opponents of abortion would say, is to go to Austin and lobby, right? Vote out the people you don't like and vote, so they'll vote in the right laws that you do like. And the court, as you already know, decided in favor of Ms. McRae and wrote, this doesn't go all the way down. Oh well, that's okay. So, for the first time, the Supreme Court says that a woman has a right to choose. The right to have an abortion is based on the right of privacy. It's a fundamental decision that each person is entitled to make on her own, and the government should have no place in intruding upon that right. Again, abortion does not exist explicitly in the text of the Constitution, but the idea of privacy does. So, and it goes through this kind of like the trimester system. The first trimester, the court says the life of the fetus is so small, is so non-viable that the state has no interest in impeding a woman's right to choose during the first trimester, so about 12 weeks. Is that right? Yeah. But during the second trimester, then the state does begin to have a stronger interest. And that interest really mostly is in protecting the life of the mother, so that a state might have requirements like a clinic has to be staffed by a doctor, it has to be clean, and things like that, so that the woman's life is protected. By the third trimester, the idea is that the fetus actually can be viable outside of the womb. And the state's interest in protecting that fetus actually is very high, as if it were an independent life. And so during the third trimester, a state actually can pass a law that says during the third trimester, we're going to ban abortions outright. And most people are okay with that. Most people understand that to be true, to be correct. And I think even California has some time after which a woman loses the ability to say, I want an abortion. So that's Roe v. Wade. And that framework lasted until about 1992. The court by now has turned more conservative. We had Sandra Day O'Connor and Justice Kennedy, David Souter, all picked by Republicans, that they came onto the court. And everybody was both either concerned or elated that now's the chance that Roe v. Wade would be overturned. And I mentioned this case because this case and the rule that this case established is actually the current rule, more so than Roe v. Wade, other than the fact that a woman has a right to abortion. And I'm not going to go through a lot of this, actually. What the general rule under Casey is now that prior to viability, meaning prior to the time in which the fetus actually can survive outside the womb, a state may not impose an undue burden. Undue, meaning a regular burden may be okay, right? So it's a shifting and lowering of the bar against the state to burden the woman. An undue burden exists where a state regulation has the purpose or effect of placing substantial obstacles, substantial, not just a regular obstacle, but a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. And O'Connor's opinion, majority plurality opinion, also says that a state actually has a right to encourage natural childbirth, and I'm sorry I can't read the rest of it, but take steps to encourage her to know that there are philosophic and social arguments of great weight favoring continuing the pregnancy, the availability of adoption. So what Casey did was basically open the door for states to try new kinds of restrictions in the name of protecting the mother. So and the state has an interest in actually saying, hey, we want life, right? So we can counsel the woman, and that's okay. You can have a 24-hour waiting period, that's okay, and so forth. So Casey stands for the proposition that Roe actually still is viable, meaning the right to abortion still exists, but the state now is kind of like, their interest is balanced against the woman's, right? And as long as the state doesn't unduly burden a woman's right to abortion, then it's still okay. That's what Casey says. So ever since Casey, we see a ton of different kinds of rules. As I mentioned before, there are physician and hospital requirements, gestational limits, meaning at what point can the state say, okay, no more abortions. If you haven't done it by now, then you've lost that right. Just something about partial birth abortions. These are later term abortions, usually required because of health reasons. There's public funding issues, mandated counseling, and things like that. And things have really, really ramped up since Trump's inauguration, because of the adoption of the two justices who came on. And so just in this year, we've seen states, mostly in the South and Midwest, adopt 58 abortion restrictions. This is as of about June, so maybe even more. And then there are states like California and some in the Northeast who have done the opposite thing, right? They're preparing for the possibility that Roe may be overturned. So, for example, in New Mexico, they're scouring the books that still are pre-Roe v. Wade abortion restrictions that never got off the books, but they were basically dormant. So they're going through those laws and basically getting rid of them in case that Roe v. Wade does get overturned. And all of a sudden, people will use, I'll be about 5 more minutes, and I'll open it for questions and answers. 5 more minutes. So,
are there any laws affecting the rights of the
Please
father?
wait, please wait.
yeah, one second.
We'll have Q&A in 5
Yeah.
minutes.
About 5 more minutes. So, so now the states are kind of gearing up, right, for the possible elimination of the right to choose. And let me just end by talking about what does that mean? So, for example, if the court does say definitively, Roe v. Wade is out, and there probably are enough votes for that, does it mean that all of a sudden abortion is illegal in California? No. It basically brings us back to pre-Roe v. Wade, when the question of rights related to abortion is a state matter, right? So it's a state matter, and even at that time, there were some states that were already moving toward liberalizing the abortion laws, like Hawaii, New York, some movement in California. At the time of Roe v. Wade, had already some protections for the woman. So eliminating Roe v. Wade would mean that suddenly there's no protection, constitutional protection, against a legislature invading the right to have an abortion. But it doesn't mean that a state has to take away those rights, right? So California, for example, I'm sure it will, continue to have protections for the right of abortion. It doesn't violate, whatever case will overturn Roe v. Wade or not. But it will take us back to a time in which, hey, any states can, if they want to, say, oh, no abortions in this state, and we're going to close down all the clinics. No problem. So I lied. There's a couple of things I want to do. I want to highlight, again, some of the more egregious laws that have been passed. And I know that when I say egregious, I'm giving my opinion. But anyway, so, and by the way, before I go into this, I am describing this process of how abortion became a constitutional right in a way that is adversarial. In other words, I wanted to try to give you a sense as to how conservatives, those on the other side, feel. Because I'm thinking that most people here are probably liberal, because humanists, by and large, are liberal. I wanted to present how Griswold, for example, was decided, how Roe was decided, in a way that the conservatives see it. They see Roe v. Wade as a wildcat decision decided by 7 judges, 7-2, who thought personally that, no, I think that the Constitution actually does protect abortion. What the conservatives would say is that it's as if the justices, 7 justices, had just rewritten the Constitution to say, Congress shall make no law, or the states, right, amending the 14th Amendment. Let's say they were creating now the 27th Amendment, to say that neither the states nor Congress has the right to regulate on abortion. You might as well have just done that. But all you needed was 7 votes, or 5 votes really, and you bypass all the 2/3 and 3/4 and all that. Stated harshly, that's how conservatives see it. Okay, so that's why it's so contentious. So what the states are doing now, Alabama, HB 314, they passed a total ban. No abortions, period. And if a doctor participates in an abortion, that doctor can be put in prison for up to 99 years. Other states have passed, like Georgia, passed these so-called fetal heartbeat rules. That's basically about 6 weeks, at a time in which the woman may or may not know that she is pregnant. And this has caught on for other states as well. And there's about, for example, 6 states in the union now that are down to having only 1 single abortion clinic in the entire state. And this has been the result of some of these laws that have been passed in various states. There's another interesting kind of movement as well. Some states have adopted abortion bans on the basis of the fetus's race, sex, or disability. The idea that you cannot have a selective form of abortion. This is a ploy. And it's a ploy because this sounds like eugenics. It sounds really bad. And the proponents understand that, well, if a person, a woman, has a right to abort for any reason up to viability, then why do they have the ability also to say, well, I want only a baby with blonde hair or something like that? Would somebody really do that? I don't know. But it just raises the idea, an ugly idea, that is contributed to the abortion debate. And so what happens in the future really is, we don't know. A lot of these obviously won't pass muster because they violate Casey. And if and when the Supreme Court takes up the case and decides, then we'll know what the future of abortion is in America. So with that, I'll open it up to questions.
Well, you know, the problem is that the male is responsible for all this. Why don't you put through a law in which the woman could bring to court this guy who caused the problem and give him 10 years in the slammer? That would change everything.
You know,
Because the male is the ones who run the country.
that's a good comment, actually. Let me comment on that. I think to avoid being even more egregious, even like the Alabama law, for example, actually doesn't penalize the woman. Right? It penalizes the doctor and the provider, but it won't penalize the woman. In other words, it won't put a woman in jail for having an abortion that may have violated the law. Having said that, that hasn't stopped some DAs in local jurisdictions from trying to prosecute women for, you probably heard the case. I have no details, but it happens, right? If you have a very, very ambitious prosecutor, they would do things like that. So I think I agree with you that if abortion affected men anywhere close to how it affects women, I think we have probably a very, very different kind of regime. But it is much easier for a mostly male-dominated legislature to have all these rules. Now, having said that, as you know, there are many conservative female legislators who feel the same way. So it is a contentious issue. It does deal with the issues of life and babies and things like that. So it's very emotional.
I noticed when referring to parties who seek to coerce a woman to carry a pregnancy to term, you identify them with the label conservative. And I don't see a connection there. Could you kindly give us your definition of conservative?
Okay. I'm going to offer what is called a normative definition. Normative meaning I'm not prescribing what ought to be the definition, but the normative meaning what is actually out there. And today, for the most part, I would say the vast majority of the people who oppose abortion are conservative. And the vast majority of those who don't oppose, who are favoring this right to choose, are on the liberal spectrum. So that's as far as I'll go. But if defining conservative, normally a conservative is somebody who is slower to change norms, right, whether it be legal or moral, and hew to a slower pace of change, including legal change. So a conservative would say that the Comstock laws that were subject of the Constitution, of the Connecticut law that banned contraceptives, well, that's a law that's been in the books for a long, long time, and is based on the sense of morality that has existed for a long, long time. If you want to change it, go ahead, change it, but don't do it precipitously with a change by a court. Do it the old-fashioned way, and if you have enough steam to change it, right, this liberal motion or energy to change it, then go do it state by state, and then eventually, maybe 20 years later, enough people in Congress will also agree as well, and then you have change. So the liberals would be a little less patient and want to make change a little faster, according to modern mores, while conservatives will want to slow it down. So that's somewhat of a definition, but I think that normatively, in other words, describing who supports and who opposes abortion, I think that's fairly correct. I'll just wait for him to choose. Are you satisfied with that? I mean, I don't want to just...
Yes, I understand the normative definition.
Okay.
Abortion is the case in which a woman once did not want to be pregnant. It would seem to me that there should be a lot of emphasis on preventing pregnancy with contraception, etc. And yet there are laws against that. Catholic Church is against that. To what extent and how can the government promote avoidance of unwanted pregnancy?
The government?
Yeah.
The government, as far as I know, does not have a lot of policies that bar a person from using contraceptives, nor do they have laws that bar people from having sex. So I don't think that that's a problem there. You mentioned the church. That's totally different. That's not the government. So we certainly do have a lot of teachings. And I think I take it back. So there are some school districts which are all governed by local jurisdictions, as you know, and they're governed by the school boards, right? So yes, there are a lot of school boards who might want to try to persuade people not to have sex, certainly not to have unprotected sex, and maybe not even talk about contraceptives at all. So yes, that's kind of public as well. But legally, no, there's no law that prevents anybody from...
But promoting sex education, for example.
Yeah.
Repeat the comment if he doesn't have a mic.
Oh, okay. So promoting sex education, interestingly, I'll give a comment because this is my biased view. I find that the same people who oppose abortion are the same people who oppose use of contraceptives. If they really, really want to have avoid this tragedy of an unwanted pregnancy and questioning whether we should stop a woman from, having an abortion, forcing them to basically raise the child, that's a very, very tough kind of decision for a government to have to make. Why not also then talk about ways to avoid unwanted pregnancies? The best way to do that is with education, is with access to contraceptives at all. But again, I think I'm right because the polls show it, the same people who oppose abortion also oppose contraceptives. Because it seems that the main goal really is to prevent people from having sex unless you're married. And that is a value that I think is a good value, but it's not a value that really works from a policy standpoint. And so this is kind of the frustrating thing. I think Clinton said it well, basically saying that a woman should have a right to choose, but it should be rare. The need to have an abortion should be rare. And everybody should agree with that, I think. But it is a good question.
Epstein committed suicide yesterday.
Don't answer questions when he comments.
Yeah, Jerry Grass. I know about this because I grew up in Massachusetts, but I don't know if you've heard of Bill Baird, but he got arrested 3 times back around the 60s, 50s, once in New York, once in Massachusetts, and once in Connecticut for just showing contraceptives to young women. So there's some kind of ban against contraceptions there.
I'm going to ask a question. Okay. So you normally don't do that, but there's not any hands up.
I'm surprised. I'm sorry.
Yeah. So if you look at the 2 top bills you're talking about that have been put out, Alabama and Georgia, if you were going to challenge those, in other words, there's going to be a case, and there'll be a pro and a con.
Yeah.
If you were the con, what would you present?
Against these bills? Okay, so for example, the 6-week, the fetal heartbeat, right? And by the way, the Supreme Court has never decided when life begins, right? The Supreme Court basically says that, if the philosophers and the scientists and the paleontologists and biologists and so forth, if they can't really answer that question definitively, then the court's not going to try to do it. The court will only just try to, in the case of Roe v. Wade, use the trimester system, and then use the idea of viability as kind of about the best line that they would draw between when the state can come in and when the state cannot come in. So, but there are many different ways that you can draw that line, right? You can think of different ways of doing it. You can think about maybe when the cerebral cortex, really comes in, maybe when the fetus can experience pain. And here, the states really have decided to use this idea of a fetal heartbeat, thinking that, well, the heart is so vital to one's existence, and if it's beating, then it seems like you can't argue that it's a life. Again, the court has never decided what is a life. The problem with the fetal heartbeat bill is that, remember, this is something that begins around week 6, which is well before viability, right? Remember the standard in Casey and Roe v. Wade is that prior to viability, the woman's right is very strong, and the state's is relatively weak. Here, that totally overcomes that concept. So that would be the main argument against that one. Of course, this one is easy. Both of these create an undue burden on a woman's right to choose pre-viability. So that would be the issue. Those two there.
I've got a question on the timing of the Roe v. Wade case. I think you said that it was brought because a woman wanted an abortion and was not allowed to have one. And that would mean to have any effect, the case would have to be decided before 9 months, obviously.
Yeah.
And we supposedly have a right to a speedy trial, although I'm not sure what that right is, since we don't have that now.
Yeah.
I was wondering if you could comment a little bit about the timing of this case and how long it took to resolve it.
Yeah. So there's a requirement in the Constitution, judicially made. It's called standing. So you have to have standing in order to be in court. And she, assuming that she did, she had the baby, but then the court didn't decide this until, I think, a couple of years after she had the baby. So the court essentially said that, this issue will never, ever see the light of day in court if we apply that rule strictly. So it basically said that she has standing. This is important enough. That is a very good question. Normally you can't. Right. If the case is moot and there's no current violation, then there's nothing that a court can decide, because a court under the Constitution can only decide cases and controversies. If you've already had your baby, there's no claim to make. Right? There's no claim to say that I wanted an abortion and the state won't let me get it. So there's no controversy there. I think Oh, sorry.
I have a question about overturning precedent.
Yeah.
I thought that precedent was such an important thing in the law. And if we were to feel that the Supreme Court could overturn previous decisions willy-nilly, I think people would have a sense of whiplash, that you just wouldn't know what was reality.
Very good question. And I did skip that part of the presentation, and thank you for raising it. Precedent is very important. Because for the very reason you said, you don't want the cases to change every time there's a new nomination to the Supreme Court. And there ought to be some kind of continuity in the laws. And let's face it, a Supreme Court decision can be a law just as much as something passed by Congress. And so there is a judicially supported ideal of, it's called stare decisis, which means let this decision stand, which tends to preserve whatever the court had decided in the past. And if you change things, you kind of like the slow accretion of changing, modifying, improving perhaps, but not to overturn a case. Having said that, we can easily think of situations in which the court should change things. The most prominent would be Brown versus the Board of Education, right? When it overturned Plessy versus Ferguson, which said that it is okay to have separate rail cars for blacks and whites as long as they're separate but equal. Right? Brown v. Board of Education said no, separate is unequal, full stop. So there are times in which the court really should exercise its discretion to change itself. Because Plessy versus Ferguson itself was a Supreme Court decision, right? Many, many years prior. I'll offer another observation. The candidates for the Democratic Party are talking about, in some sense, overturning Citizens United, which is something that a lot of liberals don't like. And they will love it if the Supreme Court would just overturn that. But they are proposing other ways to change it, like going through a constitutional convention to change Roe v. Wade, basically change the campaign finance laws, right? So, I would guess that a lot of people in this room, if Mayor Garland were sitting in the court instead, and we had another liberal justice, replace a conservative justice, they would love it if we would change and get a court to overturn Citizens United. So yes, consistency is very, very important. But if you think that it is an okay proposition that the court, one of the purposes of the court is to stand as a check against the other branches of government, then maybe you're okay with it. It meaning the court being, actively changing America for the good. But even for the good means, well, who's good, right? From whose perspective? We have now, I mentioned before that we have this so-called living constitutionalism, and you have originalism, and in the past, at least, it's true that originalism was more associated with conservative justices, and living constitutionalism is more associated with liberal justices. But now we're seeing a lot of the conservative justices actually being activists, actually applying modern mores to cases. So Citizens United, I mentioned already, is one of those cases, right? Because in the Constitution, there's nothing in the Constitution that says that a corporation is a person. And the Constitution doesn't say that spending money is equal to speech. But somehow the conservative justices found that in the Constitution and said, yep, we think that's right. So that's a form of activism as well. It's a form of living constitutionalism. So even that label is really not as clean as you might think. So it comes down to a lot of people, I have to say, you love the Supreme Court if they make the right decisions that benefit you. And you really hate it when they make decisions that you don't like. But do we want a Supreme Court that does what we want, or a Supreme Court that is supposed to do what it's supposed to do? And you have to make a decision. You either be principled or you get the right results. You can't have both. Yeah.
Yeah, so Jerry Grass, in response to the previous thing, I thought there were three major decisions in the past that were overturned. You mentioned Plessy versus Ferguson. I thought Dred Scott was another. I forget the third one. Is Dred Scott one of those that was overturned?
Directly, I'm not sure if it was overturned, but
okay.
Yeah.
Well, the question I had is, the federal government has made decisions affecting abortion in terms of Roe v. Wade, and maybe it'll overturn it. But apparently, according to that list you've got up there, the states can make quite different decisions. Is it all right for the states to come up with different decisions on this, or should the federal government get involved? I'm having a hard time framing this, but I hope you get the idea.
Yeah, so remember, Roe v. Wade was a challenge against a Texas law, right? So it was a challenge against what a state can do. And Roe v. Wade says, no, the state of Texas cannot abridge a woman's right to have an abortion. So these are states, right? All these are states. So Roe says you can't do it, right? And Casey says you can't do it. So the answer is no, they can't do it. Why did they do it? Because they want to have a case that goes up to the Supreme Court so that Kavanaugh and Gorsuch and at least 5 justices will overturn it. So this is almost not intended to actually be enforced as written. It's really intended to challenge Roe v. Wade. Does that answer your question?
No, but I'll talk about it later.
Okay. Well, maybe I'm not making it clear though. So
I don't think it's clear in my mind, what the
Okay.
question is.
yeah. So
Basically, is states can do different things, even though. Right. I'm sorry. Yeah, I mean, how can states do different things when the federal government has opinions on things?
well, there's federalism, right? So the Constitution is written in a way. Remember, the Constitution, when it was 13 states, they didn't really like the idea of a strong central government, right? They wanted to have their own laws and regulations. And I cited to you the Ninth Amendment that says that just because we didn't mention any amendment in this Bill of Rights, it doesn't mean that the states don't have that right still. So the idea of the Constitution was that, yeah, you have the federal government to take care of the Army and the post office and govern interstate commerce, but that's it. You don't get to do all these other things. States have all the powers, and they still do today. Most criminal laws are state. Marriage laws are state. Contract laws are state. Almost most of the things that you can think of are state laws. The federal government can govern things that have a federal question, right? So it's not as if every state's laws have to conform to some federal policy. That does apply sometimes, right? For example, immigration. Immigration is not a state matter. How could it be, right? You can't say that, oh, California will allow anybody to come, but Texas won't. Doesn't make any sense. So on a federal question, then yes, a state cannot go against federal policy. But a lot of things are not federal questions.
Birth isn't a form of immigration?
It's very short immigration. Yeah.
I have a question on the pros and cons of writing laws that are black and white versus writing laws that are very open to interpretation, and the pros and cons there. You know, the English language can be very precise and can define things such that there is no question, and yet a lot of times it seems like laws are written that are purposely vague. And would we be better off if we had more laws written so that they weren't as open to interpretation?
That's a very good question. It's a very big question. I can only tackle it very narrowly. So I'll talk about the Constitution. So there are provisions of the Constitution that say, for example, that to become a president you have to be 35 years old, right? Very clear, right? Look at your birth certificate. That's the answer. There's no room for interpretation there. But you also have, many of the things that we talk about today, like freedom of speech, to assemble, due process, equal protection, right? Those are principles. Those are principles that we, as Americans, say, these are the core values that we have. It would be very, very difficult to write a constitution that looks like a laundry list, right? That's not what a constitution is for. It's supposed to set forth really principles. So in that sense, I'm not sure that I would like a constitution that lists all the things that we can do, right? So for example, let's bring up the Griswold case again, the contraceptive case. One argument against how it was decided is that, well, if you don't like the fact that contraception is not listed in the Constitution, then have a constitutional amendment, right? So you can have a constitutional amendment that says that married people shall have access to contraception. Because then the next question is going to be, well, how about unmarried people? Have another convention, right? But if you go broad and say we want the right of privacy in the Constitution, well, wow. What does that mean? I'll make one last comment too. This gets to the question of what was the intention of the framers when they used words like due process and equal protection and things like that. The originalists will say, well, it means what they had in their heads at that time, right? But the argument there is that, well, first of all, how do you figure out what's in their heads way back when? And secondly, the idea of freedom and free speech and all that has to be subject to some kind of judicial interpretation. And there's no indication whatsoever that the framers said that freedom of speech means what I mean today, right? Because they will never talk about the internet, about other forms of communications. It would never be decided. So you can make the argument that the framers themselves had intended for future judges to actually interpret things based on this idea of what is equality, what is freedom.
So that kind of gets us to where we are today, where we have a difficult situation because you've got a constitution that is vague, open to interpretation, open to changing values and so on. And we've kind of gotten ourselves into a point where it's the Supreme Court that decides things. And so you've kind of taken that away from Congress. And now we have a situation where if you have one group or party that can get a few justices onto the Supreme Court, they've basically taken over the country. And
it's a very good point. I mean,
what can we do about that?
How do we get here, right? So how do we get from a Article III institution that is the weakest branch of government becoming, in some sense, the most powerful entity, anti-democratic, right? Anti-democratic. Let's face it, it is anti-democratic when 5 justices can basically overturn the laws of all 50 states in one fell swoop. That's a lot of work done by a court. So it gets down to your philosophy of what the court ought to do. If we didn't have this check, sure. The only thing I would disagree with what you said is that Congress's hands are tied. I think you said something like that. No, Congress's hand is not tied. If Congress wants to resolve the abortion issue, they should do it. They're popularly elected. They can say tomorrow, we're going to have a bill that either says, well, in the absence of what we're talking about, the court, right, says, no, we're going to have, one way or the other and do something. Now, I'm sorry, I'm contradicting myself. So it is true that under our current system, if we accept the reality, and we have to accept that it is reality, that the court does have the superpower, let's call it a superpower, to basically overturn anything what Congress and the states can do. Yeah, that does restrict the things that Congress can do. But again, Congress can, start a constitutional amendment. So yeah, anyway, it's a hard question. We are in this situation. The non-political branch has become the most political in some ways. And I think it all started when the Supreme Court took upon itself this superpower and has built it up over time. And we're comfortable with it, frankly. We are comfortable with it. I'll take it all the way to the Supreme Court, right? That's something that people have said for decades. And but I would say, personally, that the Supreme Court has done a lot of good. It has done a few bad things too, but it is a lot of good. And sometimes you have a Congress that is ineffective, and sometimes the most progress that we have made as a nation has been because of the Supreme Court. If we didn't have the Supreme Court, then a lot of the questions that we hold dearly, whether it be voting rights or gay marriage or abortion or women's rights, equality, all these things, the right to an attorney, all the criminal law and procedures, almost all of those are Supreme Court decisions. Do you want to get rid of that?
So, two-parter. In terms of what the Supreme Court has done with civil liberties, etc., it seems like they don't just do it willy-nilly, but they look at what a majority of the states have done before they put something in, or like, for example, interracial marriage or whatever.
Yeah.
And they hold off until there's popular support in some sense. Not on the level of an amendment to the Constitution, which is an insanely high level, but, majority. The other thing is with beyond the Constitution, not beyond the Constitution, but in terms of connected with original intent, to what extent has the Declaration of Independence and things like the Federalist Papers been used to decide things?
Well, originalists like to pretend that they know how to psychoanalyze the framers. And so they will use documents like the Federalist Papers, old cases, letters, anything they can find to try to say, yes, Thomas Jefferson thought this way about this decision, or Thomas Jefferson would have done this, So those things are important, but even historians will tell you how difficult it is to try to get at this idea of what is the original intent. Remember, intent is not something you can grasp. Yeah, it's not physical in nature. It is in nature, I'm sorry, but it's not something you can see and hold and weigh, right? It is purely a construct. It's a cognitive construct. And you can sit in front of a psychiatrist today and you spend 10 years and that psychiatrist will not necessarily know what's in your mind, right? So the originalists like to pretend that they're superhuman, they have superhuman cognitive abilities, and they'll use things like the Federalist Papers and da-da-da. But the fact of the matter is, this happened a long time ago, and the Federalist Papers themselves, for example, were written by, Jay and Hamilton and Madison for a particular purpose, to lobby the state of New York to try to get them to ratify the Constitution. That wasn't necessarily a majority view, right? Virginians didn't necessarily think that was a great idea, or didn't agree with everything that was said in that. So it's really hard. And even if you try to get to the heads of one framer, why that framer? Why not another framer? Why not a dissenting vote or something like that? It's very hard.
I think it's more of a comment than a question, but you talk about the originalist idea of the judicial being the weakest, and of course it's become the strongest, or seems to be the strongest, and yet it's often conservative judges who are originalists that seem to support this idea that they're the strongest, or at least that's the way it looks to me.
Well, again, I think that most people really just want results. So I don't think that conservatives today, because the court has at least 5 conservatives, really like a strong conservative court, or really like a strong Supreme Court. They didn't like it very much when Earl Warren, ran it. Yeah.
I've been puzzled about these conservatives on the Supreme Court. Number one, don't they read the papers? Now, these arguments are very rational. These people can't be all that dumb. Have you studied these conservatives on the Supreme Court to figure them out? It's ridiculous. These are so obvious.
I don't think that it's helpful to... we're talking about values here. Values, very deep-rooted values. And I am not going to try to disparage the basic values of people. I mean, even in the abortion issue, the idea of, we all, to the extent that we have children, we've been children before, it's very easy to think of how precious life is and the life of children. Oh, it's not a simple question. It's just not that simple. And I don't think that any of us has the answers. So I don't think that any of the justices are dumb or misinformed or don't read the newspaper. They have different values.